Welcome, and thank you for joining us for today's Higher Education Legal Update webinar. This webinar has been organized by the National Center for the Study of Collective Bargaining in Higher Education and the Professions, a labor management research center at Hunter College. My name is Bill Herbert. I'm the National Center's Executive Director. Each year, the National Center has held a Higher Education Legal Update panel as part of our annual conference. We decided to turn this year's legal update panel into a webinar near the beginning of the fall semester in light of the many profound legal and practical issues associated with reopening. The COVID crisis has spurred an increase in collective action by faculty and staff, including strike threats and protests over health and safety implications of reopening. Some institutions have made the decision to offer online instruction only this semester rather than in-person education, a decision consistent with demands of faculty and staff. Other schools, however, have chosen a different path, deciding to fully open campuses despite the potential health risks to students and staff. Today's webinar is the National Center's 8th in a series that began in May, aimed at presenting vital information concerning the many higher education issues during these very difficult and challenging times. We thank all the essential employees who have been working and sacrificing under stressful and difficult working conditions over the past months, and our heart goes out to those who have been stricken by the virus, have lost loved ones, and those who have lost their jobs. I'd like to express my appreciation to National Center Administrator Michelle Savarese, as well as the staff of the New York City Seminar and Conference Center for helping in putting on today's webinar. Please note that our 2020 annual conference has been rescheduled as a virtual conference for October 19th and 20th. The theme of the conference is inequality, collective bargaining, and higher education. We will be reopening registration in the next week or two for those who are not already registered. In addition, we have already begun to work on developing the agenda for our 2021 annual conference, which will be taking place on April 18th and 20th next year. The theme of that conference will be collective bargaining and labor relations in COVID-19. A call for paper has been issued, and proposals for presentations and panels for next year's conference are due by September 11th. Let me now run through a quick summary of today's webinar. In the first hour, there will be presentations by our three panelists. They will be discussing a number of legal issues related to campus reopening, the new Title IX regulations, recent decisions about faculty rights and religiously affiliated institutions, DACA, immigration, and union access issues. Aaron Nielsen, one of our speakers today, has prepared an extensive paper for this webinar, and we thank him very much for that. A link to that paper was already emailed to you, and we will be posting the link again in the chat area. So following our three speakers, we'll be opening up the webinar for questions and comments. To ask questions or make comments, please use the Q&A function at the bottom of your screen. We recommend that you start formulating your question or comments during the presentations, and please make your comments or questions succinct. Keep in mind that your comments and questions will be on the record, as journalists and lawyers might say. We will be recording the session for future posting on the National Center's website. Now let me introduce our three distinguished speakers. Henry Morris Jr. is a partner at the firm of Aaron Fox. His legal practice focuses on counseling clients, litigating education, employment, and labor law cases. The matters he covers include faculty rights, student rights, wage and hour issues, equal employment opportunity, employee discipline and discharge, reductions in force, occupational health and safety, workers' compensation, unemployment compensation. Aaron Nielsen is Senior Counsel and Director of the Legal Department for the American Association of University Professors. He joined AAUP in January of 2013 and speaks and writes extensively on higher education, constitutional, labor, and employment law. Aaron has litigated employment and First Amendment cases in federal and state courts and has retained and directed the litigation and representational work of dozens of attorneys. Christian Goebel currently serves as the Public Services Division Law Fellow at the Service Employees International Union. As the Public Services Division Law Fellow, Christian provides legal counsel to SEIU's higher education organizing campaigns, which focus on organizing faculty, graduate assistants, and non-instructional staff across the country. In 2017, Christian was awarded a Peggy Browning Fellowship, which provide law students with unique, diverse, and challenging work experiences fighting for social and economic justice. So now I'm going to proceed with turning the webinar over to Henry, and I just need to put up his slides, so bear with me. And Henry, your slides are up and ready to proceed.
Thank you very much, Bill. Thank you for the introduction. Thank you for the invitation to be here. It's quite an honor. I will be addressing today the legal and practical considerations connected with resuming campus operations, on-campus operations. Let me make clear from the outset, though, that I do not intend to address, not at all, the question of whether or not a college or university should reopen. That's a hotly debated topic in many areas and many localities. It rests in the hands of state and local officials, as well as the stewards of the various universities. It's fraught, it's a difficult issue. We've read recently about schools, including University of North Carolina, that have once decided to open and then quickly decided to close in light of the pandemic. I don't intend to wade into that debate. I really don't have anything of value to offer there. I will instead, though, discuss, again, practical and legal considerations that colleges and universities should keep in mind should take into consideration once they have decided to reopen. If we go to the second slide, please. All right. Developing and adopting and implementing a return to work plan is a necessary first step toward the movement toward reopening a campus. Each campus should develop one. And at minimum, they should address how and when employees should return to work, workplace safety protocols and procedures, any changes in employee benefits and leave policies in light of the pandemic, and lines of communications that students, employees, and others should follow if they need to address questions or have any concerns that arise. Institutions should make sure that the return to work plan is in compliance with the applicable guidance. We know that the Center for Disease Control, the CDC, has issued extensive guidance on employer operations during the time of a pandemic. It also has issued guidance specifically directed to institutions of higher education. Be sure that whoever is responsible for developing the plan consult that guidance frequently. The states and localities also have issued guidance, which is important to consult in developing and the evolution of a return to work plan. Be sure to consult that as well. I'll point out one state in particular, for those institutions that operate in Virginia. You need to be aware that Virginia is the first state in the nation that has adopted OSHA-like workplace safety standards for institutions, including colleges and universities that are located in Virginia. So be sure to consult that. Those standards went into effect last month. They are applicable now, and you want to make sure to comply with them. Treat the return to work plan as a living document. It's not something that you write down and put into the closet, never to be consulted again, but it's a living document that should evolve over time with experience and as we learn more about this disease and as guidance change over time. Be sure to designate someone within the institution or some group of people within the institution whose responsibility it is to keep up with the changing guidance as it evolves over time. And also in developing your return to work plan, be sure to involve the key stakeholders, students, faculty members, administrators, employee representatives, whoever has a key interest in the operation of the institution should have a word, in my judgment at least, in the development of the plan. That brings us then to safety obligations and what an institution could do and should be doing in order to promote a safe workplace. Could we go to the next slide, please? COVID-19 is serious business. As Bill suggested, we all know people who have been stricken. We know people who have passed away from the illness. And although it is in better control in some areas, it is still a pandemic. It is still serious. It is caused by a virus that is extraordinarily virulent. And as I said earlier, the disease can be deadly, and it's not to be toyed with. So it's imperative. It is imperative that colleges and universities, like all employers, take appropriate steps to ensure that everyone is safe while on campus and to minimize the risk of spreading the virus. Broadly speaking, that means that at minimum, colleges and universities should focus on identifying potential sources of workplace exposure. Also, the colleges and universities should evaluate measures that will minimize the potential for workplace exposure to COVID-19. That is exactly what OSHA requires. Under OSHA, there's a general duties clause, and it requires covered employers to provide a workplace that is free from recognized hazards that are causing or likely to cause employee death or serious bodily harm. Now, of course, OSHA applies only to employers in the private sector. It has no application to colleges and universities that are public. However, those of you who are affiliated with public institutions should nod off at this point, because almost certainly you operate in a state that has its own OSHA statute that in large part mirrors the requirements of OSHA. So what I have to say about OSHA, more likely than not, is applicable to the public institutions under their respective states' mini OSHA statutes. Now, if we go to the next slide, please. OSHA has developed an occupational risk pyramid that's now being displayed, and it ranks workplaces from very high risk down through high risk, medium risk, and to lower risk. And for each risk category, OSHA has promulgated various recommendations of which employers should be aware to help mitigate the spread of disease, to help provide a safe workplace. Let me just say a few words about those risk categories. At the very high risk level, there are jobs such as healthcare worker jobs, in which the incumbent performs aerosol generating procedures on known or suspected COVID-19 victims. It also includes in that category health or laboratory personnel who collect and handle specimens from known or suspected COVID-19 patients. Although I suspect that there are some colleges and universities that have jobs that fall within that category, I think they're probably relatively few. So let's move down to the next level of risk. But back to this, back to that slide. The high risk exposure group. That group consists chiefly of healthcare delivery personnel and support staff who are exposed to known or suspected COVID-19 patients, as well as ambulance and other medical transport personnel who are moving known or suspected COVID-19 patients from place to place. Again, I suspect that relatively few colleges and universities have jobs that fall within that category, relatively few, but some. The next risk category is the medium risk category. That includes jobs that in which the incumbent has frequent or close contact with people who may be infected with the COVID-19 virus, but who are not yet symptomatic, as well as people who are suspected to have been exposed to the COVID-19 virus, as well as those who have jobs that involve frequent contact with travelers to places in which the COVID-19 virus is spreading. I suspect that there are a large number of college and university campuses that have jobs that fall within that risk category, as well as jobs that fall within the lower risk category, which involves remote workers, such as those working from home during the pandemic, office workers who don't have frequent contact with, close contact with coworkers, customers, or the public, and healthcare workers who provide only telemedicine services. So that's the occupational risk pyramid that that OSHA and a number of states have adopted. Again, I believe that colleges and universities probably cluster in the medium to low risk category, but I have some best practices that I'd like to share with you that apply without regard to the risk category in which your campus might fall. The first group of best practices are those that promote the reduction of the spread of the disease. The first one is stay at home and isolate. Encourage students, encourage faculty members and other employees to stay at home. Even though the campus may be resuming operations, they should stay at home if they have tested positive for COVID-19, if they show any symptoms of the COVID-19 disease, or if they've come into close contact with someone who is a COVID-19 patient. Hand hygiene and respiratory etiquette. We all have been encouraged, and we should encourage those on our campuses to wash their hands frequently, 20 seconds at a time, using soap and warm water. If soap and warm water aren't immediately available, use a hand sanitizer consisting of alcohol, at least 60% alcohol. If people have to sneeze, encourage people to sneeze into their elbows or into a tissue. Masks. I know that some jurisdictions require that masks be worn. And of course, in those jurisdictions, we want to make sure that we comply with that requirement. But even in those jurisdictions where masks aren't required, I think it's important that colleges and universities encourage their faculty, their students, their staff members to wear masks when they're not able to maintain at least 6 feet of physical distance between them. Maintain adequate cleaning supplies. It's important that, and you'll hear me suggest later, that we want to increase our frequency of routine cleaning. In order to be able to do that effectively, we have to make sure that we have adequate sanitation supplies in common areas, in our store rooms, in our restrooms, wherever they may be needed. Also, this may seem like a relatively simple idea, but I think it's an important one. Display signs and display placards that remind people to keep distant, to wash their hands, to exercise proper etiquette when they sneeze. It's important to have those reminders. I think that the adults, the faculty, the staff understand that, but sometimes the young people, the students, need to be reminded. So I would encourage that. Some suggestions for maintaining a healthy environment. If we could go to the next slide, please. Clean and disinfect high-touch areas as frequently as possible. By that, I have in mind door handles, grab bars, hand railings, bathroom stalls, dining hall tables. All of those should be cleaned and sanitized as frequently as possible. Encourage students, faculty, and staff to keep their own personal items, their cell phones, their electronic devices, their own personal workspaces as clean and as sanitary as they can make them. Encourage them to use disinfecting wipes whenever they have to share a desk or share lab equipment with one another. And develop within your institutions an increased schedule of cleaning and disinfecting. With respect to shared objects, encourage students especially to avoid sharing their electronic devices, their books, their pens, and other learning aids. And as much as possible, within your institutions, limit the use of shared objects such as laboratory equipment and computer equipment, desks, et cetera. And make sure that if things like that have to be shared, that they are cleaned and sanitized between uses. Ventilation, that's an important one. Make sure that your institution's ventilation systems are operating at maximum capacity and that they are changing air frequently. The COVID-19 virus is transmitted is an airborne virus. We want to make sure that our ventilation systems are working at optimum capacity. Water systems. In addition to COVID-19, believe it or not, there's also a risk of Legionnaire's disease. That's because our buildings have been closed. Many of them have been closed and underutilized for the last several months. Legionnaire's disease can build up in water systems. Make sure to have them flushed and cleaned. Modify your layouts so that students are sitting at least 6 feet apart. In lecture halls, make sure that people are spread sufficiently apart. Move your classes into the largest hall that will accommodate them. Communal spaces, let's skip to communal spaces. If possible, share communal spaces such as dining rooms, games rooms, exercise rooms, etc. If they can't be closed, then at least limit their use to a few people at a time so that people can maintain social distance, and make sure to sanitize them, clean them as frequently as possible. I want to move to the next slide. For the sake of time, maintaining healthy operations. To the extent possible, limit gatherings, limit the frequency of gatherings, limit them also in size. Encourage telework as opposed to face-to-face meetings. Also encourage people to avoid, if they can, public transportation, because that is a major source of the virus spread. There are a number of other suggestions that we can talk about in the question and answer period, but in the interest of time, let's move to slide number 9, employee health screenings. The legal landscape, could we move back? Okay. Thank you. The legal landscape in this area regarding employee health screenings has changed remarkably over the last several months. The traditional rule was, before the pandemic, the rule was that employers could not ask employees health-related questions, could not require them to submit to health examinations. In most cases, there were some exceptions, but they were very limited. With the onset of the pandemic, those rules have changed. The EEOC now says that employers may ask employees questions about their health and require them to submit to medical examinations to determine whether they pose a risk of spreading COVID-19. Now, at its simplest, at its most basic, that means that an employer may ask employees if they're experiencing COVID-19 symptoms, such as fever, chills, coughs, shortness of breath, sore throat. And since fever is a COVID-19 symptom, a rather common one, the EEOC also allows employers to take employee temperatures. That's allowed. I guess the question though is, what's practical? Even though you're allowed to take employee temperatures, even though you're allowed to test employees, I didn't mention that, test employees for the presence of COVID-19, even though you're allowed to do that, is it really practical? I think not. I think the answer is no. The tests take too long. Days can pass between the time the person is tested for COVID-19 and the time the test results return. And by that time, the test result really is stale because days have elapsed. Also, we don't have a 100% reliable test just yet. There are a number of false positives as well as false negatives with the various COVID-19 tests that are out there. So in my judgment, the most practical way for employers to screen employees, and by the way, I do believe that employers should be screening employees. I think the most practical way to do it is to have employees monitor themselves. Every day before they go to work, they're asked to determine whether they have a fever and to determine whether they have any COVID-19 symptoms. And if the answer to those questions is yes, they should stay at home. They should stay at home until they have satisfied the Center for Disease Control's guidance for when someone who displays symptoms is able to leave their home, able to leave isolation. Now, let's move to the next slide, because There will be employees, no doubt. There will be employees, no doubt, who, despite all that you do, they are going to refuse to return to work. So let's talk about the rights that employees have to refuse. They do have rights to refuse to return to work. Let's talk about them under the various statutes. First, OSHA. OSHA provides a limited right of employees to refuse to work under certain, again, limited conditions. The work must expose the employee to a hazardous condition that poses a real threat to health or death. The employee must present first, before refusing to work, the employee must report his or her concern to the employer who refuses to take action. And the employee must face a circumstance in which the employee must act before OSHA can come in and try to rectify the problem. If those conditions are met, the employee may refuse to work, and it's unlawful. It's unlawful for an employer, campus, university, or college to retaliate against an employee under those circumstances who refuses to return. The National Labor Relations Act also provides protections to employees who refuse to work if that refusal is concerted. If two or more employees refuse to work because they believe in good faith that they are facing a legitimate risk, they are protected in their refusal. They may not be fired for refusing to work. Let's talk just briefly about accommodating employees who are unable to work. It will happen. It will happen that people will present to you circumstances in which they have symptoms, underlying medical conditions that make them, place them at greater risk of developing COVID-19, heart disease, diabetes, etc. The CDC has identified those symptoms, those underlying conditions, as being symptoms that place people at greater risk. And the EEOC has said that if someone comes to you with those underlying conditions and says they need an accommodation, they need to be able to stay out of the workforce for a period of time, they're entitled to a reasonable accommodation. They should be allowed, or at least you should consider allowing them to work from home, to transfer to a work location on the campus that won't expose them so much to COVID-19. There are various other accommodations that you might consider, and there are various other issues that we can discuss during the question and answer period about resumption of campus operations. But let me turn it over to my colleagues on the panel so that they can weigh in on this issue.
Thank you very much, Henry. So what I wanted to do now, because the reopening is such an important issue and there's so much has been taking place around the country, I thought I'd like to ask Aaron and Kristen to weigh in about what's been transpiring on campuses involving labor and management on these issues.
Okay, I'll go first, Aaron. This is good to talk to everybody. This is obviously a very trying time and a very complex one because there are a lot of different moving parts that are happening. I'm going to reference the AAUP website. We have aaup.org, and there's a resources tab or issues tab, and there's a COVID page that has a number of resources that you can look for further details. So the two big parts are governance and collective bargaining. On our page, we have resources on governance, and faculty have a large role in governance over certain areas, primary areas, for example, grading, how classes are conducted. Those should primarily be within faculty's control. And faculty should also be consulted on these bigger issues, such as reopening. They should not just be unilateral decisions that are made. And hopefully that is happening at universities, whether it's through collective bargaining or whether it's through faculty governance mechanisms. And again, we have material on the website explaining why that's consistent with AAUP principles, many of which have been adopted by universities, so they're consistent with and required by university principles, university handbooks, governance documents, and the like. The other area is bargaining. So in March and April, it was an emergency. There's a lot of action that had to be taken immediately, and there were really serious time constraints. It's still an ongoing situation, but the time to bargain exists. management and unions should be able to have time to bargain through issues related to reopening, how classes are conducted, and the like. And hopefully there's a relationship that allows that to happen. Hopefully there are points of contact where folks can talk to each other and, have a quick bargaining session. Bargaining does not need to take 6 months. If it's something that is going to happen within the next month, there isn't a reason that does not preclude bargaining. Both parties just have to be responsible and act quickly. One thing is that unions should be aware of the right to bargain impact, implementation, and possibly even underlying policies. If there is not a proposal from the administration directly to the union, and if there's a policy that's issued, unions have to look very carefully at whether they want to request the right to bargain. Because if they don't request it, often that right is waived. So when an administration puts out a policy, say on grading, the union should really right away look at, do we have a right to bargain and do we want to bargain this? And they should make a request as soon as possible, otherwise it might be waived. The last thing I'll say on this point is that Hunter is doing collective bargaining research. They're gathering CBAs and MOUs. They have over 100 examples. I know it was referenced in yesterday's newsletter, and they're also accepting examples by email, and they'll put out a report once it's complete. I'll just mention one other area that we've been seeing a lot of, which is intellectual property. On the AEP COVID page, we have an April webinar and PowerPoint that addresses faculty ownership of intellectual property and intellectual property issues. So you can visit that. We're also going to put out an update probably in the next couple weeks on that and expand it a bit and cover things like recording of lectures and the like, which has been another hot area that we've seen. And so those are sort of the big issues that we've seen on AEP's side.
Christian, you want to weigh in?
Sure, thank you, Bill. So I just want to begin with addressing what SEIU has been doing in this area in response to the pandemic, both nationally and as it relates to higher education. And it was really heartening to see SEIU jump out at the forefront back in March when the pandemic began to unfold. SEIU made a series of national demands to corporations, government leaders, and leaders of industry. And SEIU made these series of demands calling for fully funded and accessible healthcare for every worker in America, including paid leave and 100% paid testing and treatment for COVID. And this would include calls for corporations to provide full healthcare coverage to their employees and contractors, whether they're direct or franchisee employees. Encouraging government to enroll uninsured individuals automatically into Medicaid, calling for job, wage, and economic security for every worker, immediate investment in the health and safety of every worker, and calling on state governments to train and hire more healthcare workers and first responders during this time, expand healthcare, long-term care, and childcare coverage. Additionally, we are focusing on putting working families at the center and forefront of any packages related to the response to COVID at all levels of government. We're encouraging all elected leaders to say that working families should be at the center of any response to the COVID crisis. Specifically in higher education, as I said, SEIU has made industry-specific demands as well as national demands. And in the realm of higher education, SEIU has been calling for various actions as well and address these to Secretary DeVos, although obviously many of these actions would require action by private actors and other governmental actions beyond the federal government. We've called for making federal student loan payments optional for the next 12 months and move to a program that cancels a significant portion of federal student loan debt for education workers in particular, and including part-time faculty and healthcare workers and other frontline emergency care workers. We're calling for providing a fund for immediate professional development training for online instruction and making sure that emergency campus housing is available for workers and students who are homeless or are in homes where there's violence or an immunocompromised household. During this time, as many of us know, campus professional and service workers have been expected to remain on campus. And as Henry talked about, colleges and universities should be requiring PPE to all workers and to ensure sufficient training on the use of potentially dangerous chemicals or other solvents used in sanitation practices. Finally, we've been calling for partnering with higher education for government and industry leaders to partner with unions and associations to develop best practices for implementing any policy changes from industry or government. Additionally, SEIU and SEIU locals across the country have been engaged in bargaining, provided COVID-19 educational resources to our members, and continuing to organize during this time. We've diligently worked to provide this information, and this includes an array of information on health and safety issues, OSHA issues, accessing unemployment insurance across states, across the country. And also, as Henry and Aaron alluded to, engaging in bargaining, whether that's bargaining on mandatory decisions of bargaining that affect wages, hours, and terms and conditions of employment, but also affects or impact bargaining. And as Aaron talked about extensively, being sure to look at your contract, being sure that you have not waived your right to bargain over an issue, promptly addressing that issue so that matters can be addressed. And there are various issues coming up that are specific to higher education, particularly recall rights for contingent faculty that have been laid off extensively. Some of you may have heard about the professional staff college case at CUNY, where many adjuncts unfortunately were laid off, and a lawsuit was brought. Unfortunately, that has not proceeded. Preliminarily, the court has ruled against the union in that case. SEIU has also, in other industries, supported workers filing lawsuits against employers who have failed to protect workers, and have been successful in cases against McDonald's in certain locations and requiring McDonald's to grant workers PPE and implement precautions and safety procedures in the workplace to protect those workers. So that's just a brief overview of an incredibly expansive topic.
Thank you, Christian. So we're going to be doing questions and answer a little bit later, but we did get one question I would like for each of the speakers to comment on. A question came about the question of enforcement of OSHA in the current climate, and whether or not, how can OSHA standards and protocols be enforced in light of where we are today? Aaron, do you want to weigh in?
Sorry. Henry might have better information on the OSHA part. To a certain extent, I think it's not necessarily that productive to get overly focused on the legal requirements of either OSHA or ADA as the remedy to problems, because whether or not something violates OSHA or ADA can be incredibly fact-specific and difficult to determine. It's better for universities and faculty to get together and come up with universal policies that comply with both, and then implement those policies. Dealing with issues on an individual or ad hoc basis is very difficult and probably not very productive.
Henry, do you want to weigh in on OSHA enforcement in light of where we are today in terms of the federal government?
Sure, of course. OSHA is incredibly overwhelmed. It has a lot on its plate right now, understandably. OSHA, though, enforces its own policies, its own standards. There is no private right of action for OSHA violations. So if an individual feels that he or she is facing an unsafe workplace, the remedy is for that person to go to OSHA, file a complaint, and OSHA will take it from there and determine whether there's been a violation, and will assess whatever penalty is to be assessed. I agree also, though, with Aaron that a much more effective, I think, at least in the immediate term, way of dealing with on-campus safety problems is to have people on the campus deal with them. Have the on-campus decision makers responsible for making sure that its policies, the campus's policies, are enforced, and to bring to bear whatever disciplinary action is warranted if someone refuses fails or refuses to comply with a standard.
And one thing I want to mention that Aaron mentioned before about the research the National Center is doing about collective bargaining and shared governance in the COVID crisis. One thing that we've seen is in some of these agreements, the labor and management have agreed upon specific health and safety committees, labor management, safety, health and safety committees that deal specifically with COVID issues to be able to be flexible and be responsive to issues as they arise. So that's one area where collective bargaining can play a role. So we'll hold off on the other questions for now, and I'd like to turn it over back to Aaron to give his presentation about other issues, including immigration and other legal issues that facing higher ed right now.
Thanks. I was talking to panelists before, and I think we have probably 3 years worth of legal material to provide in this one session. So we have to go through a lot very quickly. I'm going to reference my paper and just give some page numbers. The paper has the citations and the official names and backgrounds on the cases. But I'm just going to do the highlights and also talk about what is happening, because a lot of these are really developing almost daily. And so there have been a lot of changes even in the last week or two. So I'll touch on some big ones. The first one I'll talk about is DACA. And so as everybody probably knows, the Supreme Court in June rejected the administration's attempt to end DACA. And so DACA is a program that allows undocumented immigrants to attend colleges. DHS had tried to end the program in total in 2017, and that was put on hold pending lawsuits. And then the Supreme Court found that the administration's attempt to end it was illegal, as it was arbitrary and capricious. So they hadn't taken into account all the impacts of ending the program. And so it ruled that that attempt to do so was ineffective. The administration could try again to end the program in total. That would probably take some time. And so it'll probably be something that is a factor in who is elected president next, as far as whether or not they're able to do that. However, they have, the current administration has issued interim guidance, and that was after the Supreme Court issued its decision. It has issued guidance that no new initial requests for DACA will be accepted, so it won't accept new applicants. Advanced parole, which is the right to travel internationally, will only be granted to current DACA beneficiaries in exceptional circumstances. And going forward, renewals of deferred action and work authorization will only be granted for 1 year rather than 2-year periods. So they've really limited the DACA rights, particularly for folks who are applying or having to reapply or having to go back to DHS for virtually anything. There are legal challenges to those, and we'll see where they end up. Again, that's very new guidance that just came out. Another big area is immigration and online education. Generally, foreign students taking solely online classes at American universities do not get a student visa. However, in March, the department and the administration recognized that because of the emergency transition from in-person to online, it would not require folks students who are currently here switching to online to leave the country. On July 6th, they reversed course and said they had to leave the country. A suit was brought, Harvard and MIT versus DHS, challenging that. And on July 14th, the administration backed off, rescinded their guidance that would require foreign students to leave, and went back to their initial guidance that allowed them to stay. So that was a good victory. Foreign students did not have to leave immediately. That's at page 40 of the outline is explanation of that case. And this is another one where I recently issued new guidance on, and it's applying to new international students. So ones that are not currently in class, do not currently have visas, that they will not be able to travel to the US to take entirely online course of study. So if a university is admitting somebody into a normal course of study, but their study is completely online, they have no in-person classes, they won't issue a visa to that person to come to the US. Guidance states that students will not be penalized, however, if the institutions switch from in-person or hybrid to online mode midterm due to the pandemic. So if somebody comes for in-person classes and it's switched, like North Carolina would be an example, that person would not be required to leave the country. We can talk about why, you know, the rationale behind all this is probably to a large extent political, but that's what the guidance is, and we'll see whether that holds up, because all of these are new within the last few weeks or month, and there have been challenges, and we'll have to see how they shake out. Another area that could be an entire course in and of itself is Title IX. And new regulations were issued. There's a short overview on page 28 of the material. It's really a sea change. It's a huge change. It's effective August 14th, 2020. Changes in definition of sexual harassment, required burden of proof, rights of the parties, requirements for hearings. It will likely require reworking of most institutions' Title IX policies. There were challenges to the regulations in 2 cases, and these are at page 31 of my material. They challenged the substance of the changes as arbitrary and capricious and otherwise violating law. And they sought an injunction to prevent the August 14th effective date. The 2 courts rejected the request for a preliminary injunction to stay the effective date. Those rulings only applied to the preliminary injunction, but in the course of making those rulings, both courts made statements and findings that were critical of plaintiff's case, and that, you know, some of plaintiff's arguments would not likely be successful. So while they weren't a ruling on the merits, they may have a large influence on the likelihood of success of the challenges to the merits. As I said, I'll probably require that university rewrite their Title IX regulations. This should obviously be done through shared governance. A lot of it affects employees, employee rights, appeal rights, grievance procedures, and the like, which are certainly bargainable where there's collective bargaining, and otherwise should be subject to faculty governance where there is not. Again, even though it's an August 14th effective date, that is not a reason to run roughshod over bargaining or faculty rights. Both sides should really try and expedite things if they need to, but there's time to do it. If the administration has time to write new regulations, they have time to bargain with the faculty about it. I'll just address 1 or 2 things real quickly. We have another big one, LGBTQ rights under Title VII, Bostock, which is page 34 of the material, talks about that case and how the court found that discrimination based on those factors is because of sex under Title VII. And so that'll apply to universities as well. And they'll probably need to do, in some cases, rewriting of policies. Many universities probably already recognize that, but some may not. I'll talk about 2 things that are a little bit broader, just really quickly. One is the challenges to public sector unions. Because of Janus and the general move against public sector unions, there have been a lot of challenges to 2 very fundamental underlying constitutional concepts related to First Amendment rights that would cover public sector bargaining. One is challenges to the ability of unions to be the exclusive representative of employees. And again, this is in the public sector. There have been challenges to that. The courts have uniformly ruled in favor of the unions, that under Supreme Court precedent, exclusive representation is constitutional. I think the anti-union folks are hoping there'll be a change in the Supreme Court. The Supreme Court has, at least to date, consistently denied the requests to review those decisions. This is at page 12 of the materials. Another one is the Janus and the retroactive rebates of agency fees or dues collected prior to the issuance of Janus. After Janus, all the money should be refunded, and I think all unions have done that. The question is, can you go back prior to Janus? Again, there have been a number of lawsuits. The courts have uniformly rejected the lawsuits. It would likely take a Supreme Court decision to change that. the reality is the Supreme Court has denied cert. It doesn't seem like the current court has much appetite to take these up. It's hard to say. Maybe they will. What would really change is if there was another conservative pick to the Supreme Court. That might really change the dynamic, and we could see some legitimate challenges, particularly on exclusive representation, which would be just such a radical change in the law of collective bargaining, much more so than Janus. And so there's that issue. The last one I'll mention is the racial justice, Black Lives Matter issue. I mean, it's obviously a very current issue, a hugely important one for the country. I think everybody recognizes, hopefully, not everybody recognizes, but people should recognize it's something that we need to deal with, and that we really need to look at ourselves, look at our institutions, look at our faculty, unions, senates, everywhere to see what we can do to make sure we have a more just and equal society. It's going to be a very long-term challenge. It's arising when we have all these other big challenges. I think this would be a huge portion of this if it weren't particularly for COVID, but it's something we have to address over the years. The big issues legally are the affirmative action ones. They're in the paper at page 26, and the recent Department of Justice just on August 13th finding that Yale discriminated. So it is a very hot political issue. Legally, again, it may very well depend on the election and whether or not the Department of Justice is willing to continue to prosecute these cases. On this one, AEP has a resource page. I put it in the chat box. It's www.aep.org. One issue is COVID, and so we have an issue page on there, and another issue is racial justice. So if you go to the issues tab, you'll see those pages that have a lot of resources. So that's what I have on many of the broader issues, and I'm happy to discuss as needed. Thank you.
Thank you, Aaron. Kristen, do you want to proceed with your presentation? Need to put on your sound, on your microphone.
Yes, so I can proceed with my presentation. Let's see, just sharing screen real quick. All right, can everyone see the PowerPoint? All right, great. So good afternoon, everybody. Thank you, Bill and Hunter College for putting on this presentation. It's great to be here. So today I'm going to be discussing two issues where there have been changes in the law under the National Labor Relations Board in two specific areas. I'm going to be talking about non-employee union representatives' ability to access the employer's property under the National Labor Relations Act. The second topic addresses recent decisions concerning the Act's jurisdiction over religiously affiliated colleges and universities. So the first issue regarding access to an employer's property, I want to begin by discussing the rights in the statute and a seminal Supreme Court decision in this case. So under the Act, as many of you know, employees have the right to engage in protected concerted activity, and it's an unfair labor practice for an employer to interfere with these rights. And so based on these statutory provisions, the board and courts have held for a long time that employer cannot restrict employees' right to discuss self-organization among themselves unless the employer can demonstrate that a restriction is necessary to maintain workplace production or discipline. But it's important to note that the Act does not confer this right on non-employees. And the general rule from the Supreme Court's decision in Babcock and Wilcox is that an employer can deny access to its property by non-employee union organizers. However, there are two important exceptions to this general rule. This is the inaccessibility exception and the discrimination exception. And under the inaccessibility exception, in order to gain access to the employer's property, the union must show that there are no other reasonable means of communicating its organizational message to the employees. Under the discrimination exception, the union has to show that the employer's access rule discriminates against union solicitation. So today I'm going to be discussing cases that address the discrimination exception. The first case is University of Pittsburgh Medical Center. This was a case that was decided last year, June 2019. And this case, the facts of this case briefly are that two union organizers entered a hospital cafeteria. They purchased lunch and sat down with employees at a cafeteria table to discuss union organizational matters. The hospital security did eject the organizers from the cafeteria, and subsequently unfair labor practice charges were filed. Now, coming into this case, the previous rule had been that non-employee union organizers cannot be denied access to cafeterias and restaurants that are open to the public if the organizers use the facility in a manner that's consistent with its intended use and they're not disruptive. So the board has consistently found that an employer may violate the act when they restrict this type of access. Now, the board in UPMC established a new standard and held that an employer does not have a duty to allow use of its facilities, including cafeterias or restaurants that are open to the public by non-employees for promotional or organizational activity, absent discrimination between non-employee union representatives and other non-employee groups. Now, a few months later, the board issued a case on the similar topic of the discrimination exception. This case was Kroger Limited Partnership 1, Mid-Atlantic. Now, this case dealt with management ejecting a union representative from the Kroger store parking lot. The union representative was circulating a petition requesting a specific action to be taken by the employer. The union organizer similarly was ejected from the property by police. Now, coming into this case, the previous rule had been that the board had taken a broad view of what constitutes discrimination under the act in this area of the law that is sufficient to trigger an employer's access obligation. And the focus was simply on whether the employer had permitted non-union actors to engage in solicitation and distribution on its property, regardless of whether those actors were otherwise similarly situated to the union in terms of their identity or aims. Now, the new standard that the board established was that denial of access claim to union organizers, in order to prove that a violation had occurred under the act, the general counsel must prove that an employer denied access to non-employee union agents while allowing access to other non-employees for activities that are similar in nature to those in which the union agents seek to engage. So consistent with this standard, an employer can deny union organizers access for organizational activity if they're similarly denying access for that purpose by other groups. And implying this standard, the board dismissed the union's ULP case in this case. And this was so even though that Kroger had an extensive history of permitting other civic, charitable, and commercial organizations engaging in solicitation and distribution of literature on the employer's property. So taken together, UPMC and Kroger have the effect of making it more difficult for union organizers to communicate their messages to employees on the employer's property. And thinking about this in the higher educational context, union organizers who are looking to organize non-unionized private colleges and universities will need to be thinking about the employer's solicitation and distribution policies that are applicable on campus. And if they do not, you may want to be thinking about if you can find information related to what the employer's practice or pattern has been in its treatment towards other non-employee groups' access to the employer's property. So now I want to turn to the second topic, which concerns the Act's jurisdiction over religiously affiliated colleges and universities. And I want to begin by setting this discussion of the recent cases with a background of applicable precedent. So this begins with the Supreme Court's seminal decision in NLRB v. Catholic Bishop. And the issue in that case was whether the board could exercise jurisdiction over lay teachers at parochial high schools. And the Supreme Court in that case held that the board could not assert jurisdiction over these lay teachers at the parochial schools because they were concerned that it would create a significant risk that First Amendment rights under the First Amendment's religious clauses would be infringed. So after Catholic Bishop, the board really decided on a case-by-case basis whether a self-identified religious school had a substantial religious character that would risk First Amendment infringement rights of the school. And this continued until the DC Circuit's opinion in University of Great Falls. Here, the Montana Federation of Teachers had filed to represent a unit of lay teachers at the university. The union did win the election. They were certified. The board ordered the employer to bargain, but the university took the position that they were exempt from the board's jurisdiction under Catholic Bishop. So the case was taken to the DC Circuit. The DC Circuit rejected the board's standard, then applicable standard at the time, and refused to enforce the board's order. And the DC Circuit established their Great Falls test. And under this test, in order for the board to exercise jurisdiction over a religiously affiliated college or university, the court held that the board must examine whether the institution holds itself out to the public as a religious institution, whether the institution is nonprofit, and whether it is religiously affiliated. And if a university satisfies this test, then the board should decline jurisdiction. Now, after that case, the board neither really explicitly rejected or adopted that test. So in the Obama era administration, they established a new standard, and this is the standard under Pacific Lutheran University that was recently overturned this year. And under this standard, the board would exercise jurisdiction over faculty at a college or university unless the institution demonstrates as a threshold matter that it holds itself out as providing a religious educational environment, and then it holds up the petition for faculty members as performing a specific role in creating or maintaining the school's religious educational environment. And the board in these cases would examine evidence based on public representations made by the college, based on handbooks, websites, mission statements, corporate disclosure statements. They would take these representations at face value and wouldn't question the good faith of the institution. So that brings us to the recent decisions that were issued this year. Duquesne University of the Holy Spirit, the NLRB, this was decided in January 2020. Similar factual situation arose at Duquesne University. The steelworkers petitioned to represent adjunct faculty. Similarly, the institution resisted and stated that they were exempt from the board's jurisdiction. Again, a panel majority of the DC Circuit held that the PLU standard was still impermissible under the Supreme Court's decision in Catholic Bishop. They rejected the board's PLU standard and reaffirmed their adherence to the Great Falls test. And examining the Duquesne University under the Great Falls test, the DC Circuit panel determined that the board did not have jurisdiction over that institution. So just a few months ago, after the Duquesne University decision, the board issued their ruling in Bethany College. And the board, in this case, took the opportunity to themselves overturn the Pacific Lutheran University standard, and they did adopt the Great Falls test. So moving forward, the board, in order to determine whether they will exercise jurisdiction over a religiously affiliated college or university, they will examine whether the institution holds itself out to the public as a religious institution, is nonprofit, and is religiously affiliated. And if the institution meets the test, the board will decline jurisdiction. There has been an interesting development. A decision issued by the Supreme Court in Our Lady of Guadalupe School v. Morrissey Barrow was issued in July after the Bethany College decision. Now, this case is occurring in a different context, but has parallel First Amendment concerns under the religious clauses. This case concerned parochial elementary school teachers who had brought employment discrimination claims against their parochial schools. And the court in that case had determined whether these parochial school teachers had the ability to bring these claims against their school. So the court in this case examined whether the teachers fell within what is called the ministerial exception. And under the ministerial exception, courts are required to stay out of employment disputes involving individuals who hold certain important functions with churches and other religious institutions. And this rule is based on the idea that the First Amendment protects churches and religious institutions to handle their own internal affairs and to select the individuals who play these important key functions within their institutions. So in determining whether these individuals did meet the ministerial exception, the Supreme Court stated that what matters at bottom is what an employee does. And in conducting this inquiry, the court examined extensively the functions that were performed by the teachers, the religious functions. They looked at their employment agreements, they looked at what they did during the day, how they interacted with their students, and found that based on those activities that they did indeed meet the ministerial exception. So how does this case apply to Duquesne University and Bethany College? The parties in Bethany College filed a motion for reconsideration with the board, arguing that the Supreme Court's decision in Our Lady of Guadalupe refutes the proposition that it is impermissible for the board to conduct an inquiry to determine whether faculty are playing religious or non-religious roles. Now, the board denied that motion for reconsideration on August 10th. They really did not acknowledge this issue or discuss it much. It was a flat refusal. Now, at the DC Circuit Court of Appeals, as I said, that issue, that was a panel decision. And the steelworkers have filed a petition for rehearing en banc, which means the case would be heard by the full DC Circuit. They're arguing the same thing, that the Supreme Court's decision refutes the proposition in Great Falls and Bethany College that the board cannot conduct that type of inquiry. And that motion is still pending before the DC Circuit, so that remains to be seen whether that case will be taken up. And that is all I have. Thank you.
Thank you, Christian. So we're going to move on to questions, and we have a short amount of time, so I want to group some of these questions together. They're all excellent and very practical. So one question comes is, what is the role of faculty if a student refuses to wear a mask or social distance? And what protections does the faculty have for their responsibility with respect to safety standards? Another question which is related is, what about taking temperatures of the students who come on campus? And related, who does that? And then the next question is, are employers able to or obligated to share with other employees if a colleague tests positive for COVID-19? So Henry, do you want to start with the first question with respect to faculty's role in enforcing health and safety issues in the classroom? Henry, you have to turn your microphone on.
I apologize. If a student refuses to wear a mask in class, I don't think that student should be allowed to enter the class. I think it's as simple as that. And I think that the faculty members should instruct the student that the student should not be allowed to enter. Now, what kind of backing, and I think the university should stand foursquare behind the faculty member in doing so. Now, I will ask Aaron or Christian to talk about how, in practical terms, the university can stand behind the faculty member. But in my judgment, that's absolutely necessary. The standard, the face mask requirement is a nullity unless someone enforces it. And I think the person to enforce it is the person closest to the ground at the time, who is a faculty member in the class.
Yeah, I think that it's something that probably is best addressed by the faculty and the employer working together to come up with a plan, because this is a fairly predictable outcome. And so our masks checked when people walk in the building, that would make the most sense. You know, is there somebody the faculty member can call to alert folks, you know, to get assistance? Because I think the non-wearing can also often be a contentious issue. You know, it's not just a matter of not wearing your shoes. A lot of times it's a politically loaded one. And so there should be some discussions and planning around how to deal with it. I think Henry's right. The administration should totally back the faculty, and the faculty have the authority in the classroom. And this is a classroom matter. It's not a political matter from the perspective of the faculty member. Just as faculty members have a right to enforce, wearing shirts in class, they should have a right to enforce wearing masks, but there should be backup and a process for dealing with contentious situations.
Christian, do you want to weigh in?
I would just echo what Henry and Aaron said. I think faculty, staff, administrators should all work together. And then on the ground in this situation, I think, it will be, hopefully it's not as particularly contentious, but as we've seen widespread in the media, there are people who are fighting using masks. And as Aaron said, there should be a process in place and a detailed policy of what institutions are instructing faculty and other staff to do when a student refuses to comply with that, to be sure that the administration is backing faculty and campus workers, particularly if they're not shutting down common areas and if there are still common areas open where there may be higher volume traffic. That could be a potentially serious issue.
So the next question related is about testing of students, whether taking temperature or actually doing tests with regard to the virus. Henry, do you have any views about whether an institution should be imposing that as a requirement before the students are allowed to enter a classroom or enter a building?
In terms of legal right, the right exists, barring something that's contained in the individual student's agreement with the campus, with the college or university. However, for the same reasons that I think that it's impractical for an employer or for the institution to take employee temperatures daily before entering the workforce, coming onto the job, I think it's also impractical for a school to impose that requirement on students. That is, for the school to take the student's temperature every day. Again, by the time you get the results, typically the information is stale, and also there are just so many false positives. In terms of testing, I would leave it up to the student to self-monitor, to take his or her temperature on a daily basis, to monitor his or her symptoms on a daily basis, and instruct the student that the student is not to come on to not to come on campus if the student is off campus, and if the student is on campus, to isolate in his or her room while the temperature is raised, while the symptoms are present.
Aaron or Christian, do you have any response on that issue?
No, I would just think, I think I would agree with Henry. I think it would be a great idea if universities and colleges required that. And if they provided, even if they could provide thermometers to students to be able to do those checks themselves, perhaps, if a university or college is still operating their dorms at a reduced capacity, you could see a situation where that could be widely available to students and facilitating that through the dormitories.
No, and I agree. I think Henry makes a great point of practicality, and I think that's where it is important, again, to come back to shared governance and making sure that administration takes into account the views and anticipated problems that people working on the ground feel are coming. Because sometimes these things come down that are hypothetically sound good, but are not practical. And most of these are things that can be dealt with planning, in the sense of at least defining who is responsible for what kind of backup there are, what kind of contact there is if there's a dispute, who actually, if there's a requirement for mask, who enforces it, and thinking through practically how that works. And that really benefits from having the views of not just faculty, but other administrative staff and other staff. And I think that's one thing we have seen a lot of it, and you alluded to, Bill, is there's a lot more unity on campuses from employees, from faculty to staff to administrative staff and the like. They're often all in the same boat as far as risk. And I think there's been a lot more coordination between those groups, and it's a very healthy thing because they're all facing the risk, and that's a good thing to see happening.
I mean, one thing that these questions raise is a question of job security for those who are faculty or others who don't have tenure or job protections. And so we have a question which raises that, which the question is, the campus has adopted a safety pledge that calls for termination if a faculty member knowingly violates the pledge. Does this pledge violate just cause as defined in a collective bargaining agreement? In other words, there's a pledge requiring that saying that a faculty member will accept being terminated if they knowingly violate a health and safety pledge. And is that consistent with a just cause provision in a collective bargaining agreement?
And that's to me, I think that's a complicated and multi-layered question. I mean, there's a question of whether you can force somebody to sign it in the first place. Whether refusal to sign would be a basis for discipline. And that's going to depend on the collective bargaining agreement. Again, that's probably going to be a campus-wide issue, and it's something the union should investigate and not have it dealt with on an ad hoc basis. And the same is true for waivers of liability and assumption of risk. If the employer unilaterally puts out a policy or a notice saying that, if you, without requiring a countersignature, if you do this, you will be terminated, whether it's just cause under a collective bargaining agreement is probably going to depend on whether it's reasonable, whether it's necessary. whether there's been adequate notice, whether there's been adequate training, whether there are exceptions. I think, as I said before, it's again one of these things that's probably very difficult to deal with on an ad hoc basis because it may depend on the unique circumstances of the faculty member. It's better to have everybody agree to a policy and how to implement it.
Our next question raises the issue of whether if an employee refuses to work because of fear of COVID, must the employer continue to pay them?
Let me jump in, if you don't mind. The answer is no. If a person has an underlying condition and is exposed to, pardon me, and suffers a greater risk, runs a greater risk of contracting COVID and being disabled or killed because of COVID, yes, that person is entitled to accommodation. But even that person doesn't have to be paid if the person is not working. A person who just has did you say a generalized fear of COVID?
Yeah, that was the question.
Oh,
Fear.
there's no underlying medical condition. The person just has a generalized fear. That person is not entitled to an accommodation under the Americans with Disabilities Act. What I would do under those circumstances is encourage the institution to communicate with the employee, explain to the employee everything that the university is doing to provide a safe workplace. And if the employee still fails to come in, I would be inclined to advise the institution to treat that as a job abandonment.
On the question of changing the question slightly, if the person has COVID-related symptoms, though, there's federal law now that requires granting paid leave for people with COVID-related symptoms, as well as for family members, expanding FMLA for families that of someone who has COVID-19 conditions.
Yes, that's the Families First Coronavirus Response Act, and it does exactly what you said. It does provide for a period of leave, paid leave for those individuals, as well as for individuals, and I think this is going to be a common occurrence. It provides for paid leave for those individuals who are unable to work or telework because they have to care for their kids who are home because the school has closed or because the schools are only operating remotely. So yes, there's leave available, paid leave available under those circumstances.
Another question asks whether an employer can require employees to do completely different set of tasks during the crisis, including tasks that require much more exposure to large numbers of people than they normally have to do during their regular job.
This is another multi-layered question. It will depend first upon whether there's a collective bargaining agreement in place. A collective bargaining agreement will usually will define what an employer may do in terms of increasing or changing an employee's duties. Also, where there's no collective bargaining agreement in place, it will turn upon the extent to which there is an individual employment agreement, if there is one, and what kind of latitude it grants the institution.
Yeah, and I would echo that and again come back to something I said earlier, which is it's probably better for the faculty and universities to come up with broad policies that are easy to understand and implement and clearly meet the requirements of ADA, OSHA, and anything else that applies. Because there's a big risk on both sides if you get into these individual ad hoc decisions, for example, on not returning to work. Because on the one hand, the employer doesn't know if maybe the person has an ADA accommodation and they haven't engaged in enough conversation with the person, or that there are other legal bases so they could be liable for back pay. The employee doesn't know if perhaps the employer has a justification for termination. And that creates a lot of uncertainty and risk on both sides. It's better to have clear and expansive policies that are easy to understand. And that's what I think what most universities have done. And also to make clear that they're to look for as many ways to perform work from home as possible, whether it's remote classes, whether it's doing administrative work from home for those who cannot or cannot return to work or who do not want to. Now, where exactly that line should be on cannot or do not want to, I guess is an open question. It obviously should be well past what the legal requirements are, but how far past is, I think, universities have approached differently.
And Bill, if I may, this all goes back to some discussion, the earlier discussion about return to work plans. To the extent possible, I fully agree with Aaron, to the extent possible, these issues should be addressed in advance and incorporated into the return to work plan. And that's why it's so important to have a variety of stakeholders involved in developing the plans so that these issues can be anticipated and the people can think through the optimum way of responding to them.
So someone has asked a question, which asking for more details about how do employees individually determine if their workplace is unsafe and therefore to opt out of continuing to teach in person. For example, the HVAC system in the room is outdated or issues like that. How can an individual faculty member or staff member figure out and make a determination about whether or not their workplace is unsafe to continue working in person? Aaron and Kristen, do you have any thoughts about the role that your unions would play in such a situation, providing health and safety advice?
Yeah. I mean, I think that's an excellent place for the union to have some role. Obviously, the union doesn't control the buildings, but they are able to have and bring a higher level expertise to that question. And again, a lot of these questions are ones that repeat themselves throughout the campus, whether it's this type of question or the question on waivers or the question on signing a form. These often are uniformly applied, and there should be a uniform response.
Yeah, I would just echo that as well and say if you're engaged in mandatory bargaining over health and safety, you can also, as many of you know, as union representatives, submit a request for information in connection with your bargaining demand. So you can try to obtain information that way as well.
And many unions have health and safety specialists who can provide professional advice about these questions and can conduct or participate in investigations of the workplace. In addition, there are advocacy groups outside of labor that are involved with health and safety issues regarding the workplace, and they may be able to provide more guidance on the question. So
yeah, and I think also, just very quickly, I agree with Christian. It's a great point about requesting information. I think that also exists if it's related to a grievance, and sometimes with respect just to ongoing representation by the union. So the union really should be, or the union and union context should be assertive about asking for information if it's relevant. In the non-union context, a lot of times you have Freedom of Information Act requirements, or just general faculty institutional governance requirements for information sharing.
So one question that's been asked, which relates to unemployment, is a question about unemployment for adjuncts and the issue of questions of unemployment benefits being awarded to adjuncts and then being required to repay those benefits. Henry, would you want to weigh in about unemployment issues relating to adjunct faculty?
It's largely a state issue. It's going to be governed by the state's unemployment compensation laws and regulations. I don't have any particular insight as to how those laws and regulations apply to adjunct faculty who find themselves unemployed for reasons beyond their control. I can say this, though, that it is not uncommon. I know this from experience. It is not uncommon for an unemployment compensation agency, if it later determines that has awarded unemployment compensation, if it later determines that the unemployment compensation should not have been awarded, to seek to recover what has been awarded. That is not uncommon at all in my experience, but how it plays out in the specific example that is implicated in the question, I'm afraid I can't address it directly.
And also, I just note that there is material out from the federal government addressing unemployment compensation and COVID, and often a generalized fear of COVID at work is not enough to be a legitimate quit for the purposes of getting unemployment compensation, but a specific fear because of danger to the person or family may be sufficient to get unemployment compensation. And also, I think we've seen in a number of states that employers are often not contesting quits for COVID-related reason, in the sense that they're unemployment compensation benefits are being granted, even if there's not a specific physical threat to the employee.
So we've covered a lot of territory and we've not been able to get to all the questions. I just want to give an opportunity to each speaker to do a quick summation of about 1 minute to sum up their views about where we are in the area of the law with respect to higher education and the COVID-19. Henry, do you want to start?
These are unprecedented times. We have never seen anything like this in our lifetime. COVID-19 arrived on our shores and has overtaken us like a tsunami. And it's as I said earlier, it's a serious issue that can't be dealt with lightly. I believe that what we've heard from Aaron and Christian is spot on, that it's hard to speak specifically about individual circumstances in this context, but the idea of working collaboratively with the stakeholders, including employee representatives, to anticipate these issues, to think through these issues before they become emergencies on the campus, and to develop solutions in advance, I think is critically important. So I heartily endorse that approach.
Aaron?
Yeah, and I agree with Henry. I think, and he said this from the beginning, that, you know, really should be a collaborative approach, and it should be one that involves all the stakeholders and where we think through these issues in advance, because that's really where it's going to work. Litigation about this stuff is not that productive. It takes too long to get answers. It's too uncertain. And it's just too particular to the individual to have much of an impact other than in maybe some very broad areas. So it's better for the parties to get together, plan things out, have reasonable procedures and rules, ones that are clearly, you know, enough to comply with the law, and probably even more so that you don't have any kind of questions on the margins, and to include everybody. And unions and faculty senates are great at that because they can accumulate resources. And as I said, there are resources on the AUP webpage. I'm sure there's others. We have a lot of links to the government web pages and others. So you can go there for that type of information.
And Christian?
Thank you. I'll just echo what Henry and Aaron have said. I think this, obviously, everyone knows this is an incredibly difficult situation, and it is heartening to see labor and management working together where they have been productively and being flexible in addressing this process and ensuring that faculty, staff, graduate assistants, and students all have a voice in how reopening is done and whether that is done in person. And it's unfortunate to have seen so much inaction at the federal level. And hopefully more states similar to Virginia and Oregon will step up to implement guidance to institutions and the public in general, so that hopefully this process can unfold more smoothly in the future. So thank you.
Well, thank you, Henry, Aaron, and Christian, for your presentation today. On behalf of the National Center, I want to thank everyone for joining in on this webinar. For those who want to go for a deeper dive into the laws being discussed, I recommend you download Aaron's fantastic paper. We're going to be distributing the PowerPoints to anyone who wants them, the Henry's and Christian's PowerPoints, so that'll provide additional information on legal issues. And we should also mention that this webinar has been recorded, and we will be posting it once it's available on our website. And lastly, we're going to be doing, and we hope to be doing, additional webinars along the way, probably after our October 19th, 20th annual conference. And I encourage you all to consider registering if you haven't already. Thank you again. Have a great day. Stay safe and be healthy. Bye-bye.